Ma'am, would you turn your video on for me, please? This is 231964 LT. This is West Village Estates versus Angela Hughley. May I have your appearances, please?
John Capitan appearing on behalf of West Village Estates.
Ma'am,
Yes.
turn your video on and state your name for the record, please.
Okay.
And to stay in possession.
How do I?
Section 8 on the money.
Are you actively in the other hearing, sir?
No, I just muted it. I'm sorry, Your Honor.
Okay, that's okay.
Okay. I'm in the process of trying to turn my video on. Okay, so.
Ma'am. Ms. Hughley? Oh, for the love of mankind.
Yeah, here I am. I'm trying to lip read the other judges.
Why are you trying to lip read?
No, just to see if the other judge is calling my next case, because he was reading a ledger from another case. Uh-oh.
Go ahead.
All right, thank you.
Ma'am,
Yes.
the attorney is here, but he has a case in another court. We were trying to get your case called before 9 o'clock so you wouldn't get stuck behind this other hearing. But because you couldn't get your audio and video connected at the same time, I told him to go back to the other court. So when he's done there, he's going to turn his head and I'll recall the case. Are you at work or something?
Yes, I'm at work and we build vehicles and it's hard for me to Zoom at work because we on like standard timing schedule.
I understand, ma'am, but if your case was scheduled at 9 o'clock, were you prepared to have your case heard at 9?
Yes, I'm just new to this Zoom, so I was going through the video and the unmuting and all the things.
How long are you able to be away from your station?
I got about 9. I start at 9. I'm able to do that. I got about 15, 20 minutes.
Okay. The gentleman that's in the suit with the red tie, as soon as he turns his head back this way, we'll start your case, okay?
Thank you, ma'am.
You're welcome. Thank you.
All right, thank you, Your Honor.
Thank you, sir. Ma'am, state your name for the record, please.
Angela Hughley.
Thank you. Today is the day and time set for hearing on the on the defendant's motion to set aside the default judgment. Ma'am, the court has had the opportunity to review your motion and did not receive a written response from the Levine Law Firm. Would you please put your motion on the record? Explain why you're here.
Because I want to work out some type of pay arrangement to where I can pay up, all my late fees and everything with my past due balance of rent.
Why didn't you appear for court on either May the
'Cause
10th, which was the first hearing date, or May the 24th, which was the adjourned date?
Because it's hard to Zoom at work. When we inside, the plan is just hard. Sometimes our brakes change. It's just a lot going on inside with building vehicles. Our timing can change, our our brakes can change. Sometimes everything is not scheduled, the way it's supposed to be. It's always subject to change.
Mr. Capitan?
Well, Your Honor, I mean, I've read the motion, and first off, I don't see a reasonable likelihood of success on the merits because there's no dispute as to the amount owing. There's nothing else. It's just, I want to work out a deal. And I don't believe that that's enough to set aside a default judgment. Additionally, I did see that possibly the production line or what have you may allow for the tenant defendant to have been available for the hearing. However, there could have been arrangements made at that time. Therefore, I request the court deny the motion.
Anything else, ma'am?
No, ma'am.
Do you dispute the amount that's listed in the judgment in this matter that shows that on May the 24th, you owed West Village a total of $3,767.87?
No disputes at all, ma'am.
Have you paid any money towards this judgment?
No, ma'am.
So Ms. Hughley, what was it that you intended to do about this past due rent?
Just pay it all up.
Ma'am, the court has had the opportunity to review your motion, and while this court is extremely sensitive to people who work in the types of jobs that don't allow them to sit on Zoom for long periods of time, in reviewing the file, there is no indication that you contacted court staff on May the 10th or before your May 10th hearing, which was the first hearing, or May 24th, which was the second hearing, requesting an accommodation. This court, again, would have made arrangements to have you either come late or be very time specific so that you did not have to be off the line longer than was absolutely necessary to conduct this hearing. So number one, there's not good cause for you failing to appear. Secondly, as to your meritorious defense, you don't dispute the amount of rent due and owing, and although the judgment's been in place for approximately 1 month, you have not paid any money towards that $3,767.87 other than the escrow that was posted, which was a condition of your motion being set for hearing. That being the case, the court will deny your motion to set aside the default judgment in this matter. There was also an application in order of eviction filed by the plaintiff's office on June the 12th, 2023, which indicates that zero monies had been paid towards that May 24th judgment. Mr. Capitan, is it your client's intention to proceed with this application for eviction?
Yes, Your Honor, it is.
Ms. Hughley, this court has no alternative other than to sign the order of eviction that was duly filed, inasmuch as you have not made any payment towards this outstanding balance. And you now have June rent that's come due and July rent will come due within the next 11 days. Anything else, Mr. Capitan?
Your Honor, I do have a proposed order that I can submit to the court. It simply states that the Motion is denied for the reasons set forth on the record. Any escrow be released to plaintiff, although I don't believe that there's any escrow. And that the order of eviction be immediately issued.
If you would submit that order to the court, Mr. Capitan, there is actually $540 in escrow that this court will
Oh.
release to your client.
All righty, I will do so.
There is, if you can get that emailed over to the civil department, the court has already signed that order of eviction that was received on June the 12th, 2023, sign it effective today. Anything else on behalf of the plaintiff?
No, Your Honor.
Anything else, Ms. Hughley?
No, ma'am.
That concludes this matter. Have a good day.
All right, Your Honor,
too.
thank you for
Thank
your
you.
accommodation. It's greatly appreciated.
Understood. Take care, sir. Ms.
Or you too.
Harrison? Ma'am, the plaintiff's attorney is not here yet. The case is scheduled at 9 o'clock, but if Ms. Cohen or someone from her office comes on early, I'll come out and we'll get the case called, okay?
Mr. Mitchell.
Yes.
Hi, good morning. Ms. Kalish, do you need a breakout room with Mr. Mitchell?
I'm certainly willing to chat with them, Your Honor.
Oh, hold on one second, please.
Thank you.
Yep, you're welcome.
Clerk, whoever you are.
Good morning, Mr. Asbach. How are you? Do you need a breakout room with Ms. Harrison?
Yeah, I'd be willing to talk to her.
Okay, thank you. Ms. Harrison, you're going to see an invitation to join a breakout room. Please click on that.
Okay.
Mr. Asphalt, did you tell Ms. Harrison to come out?
I did, Your Honor, but I don't know if she's able.
I just forced her out. She was just a little sluggish. This is 220897 GC. This is Covington Apartments versus Harrison. May I have your appearances, please?
Christopher Asphalt 53129 on behalf of the plaintiff.
Ma'am, turn your video on and state your name for the record.
Okay. My name is Navia Harrison.
Thank you. Today is the day and time set for hearing on the defendant's objections to garnishments. The parties have had the opportunity to speak. Mr. Asphalt, is there any resolution?
No, Your Honor.
Ms. Harrison, please present your objections to the court.
Well, this case was dismissed a while ago in 2020 in Washtenaw County. And they said, and I was notified of this until the Treasury contacted me and said they wanted to garnish my money, my taxes and stuff. So I don't know why this case is even going on right now because it was dismissed.
This same, I'm sorry, GC case, ma'am, was dismissed out of Washtenaw County?
Yes, ma'am. It was dismissed in Washtenaw County.
Mr. Asphalt, your response?
Your Honor, this case, a default judgment was entered in June, I believe, in this court. I do not believe the defendant has stated any valid reason why this garnishment for income taxes should be denied.
Anything else, sir?
No.
Anything else, Ms. Harrison?
No, that this case was dismissed and it was in Washtenaw County, and I'm not a resident, or I haven't been in Wayne County in over 5 years, so I'm just kind of confused.
Ms. Harrison, I'm looking at the summons that issued in this case. It indicates that there had previously been a case in 14A1 District Court, which is a Washtenaw County District Court. It gives the case number of 211C0238LT, indicates that case is no longer pending. The LT indicates to the court that it was a summary proceeding for you to, it was either a termination or a non-payment case. It doesn't say in the filings. The case that's before this court was a GC, which is a general civil, which is the plaintiff's efforts to collect monies from you. Ma'am, what you filed with the court is an objection to garnishment. That objection to garnishment has to indicate that there is something wrong with the garnishment. You cannot use an objection to garnishment to attack an underlying judgment, which is what it sounds as if you are appearing to do. You did not mark any of the boxes that would indicate that there is something deficient in the garnishment in and of itself. Based on that, this court is required to find your objections invalid.
Well, can I have a 60-day discovery, because it was dismissed, and then on top of that being dismissed, after the dismissal, 3 days later, they locked me out the apartment. So, and with it being dismissed, I mean, and then trying to serve me in Wayne County, and this didn't happen in Wayne County, it happened in Washtenaw County. I thought I'd be in the Washtenaw court, and then I guess he tried to go back to Washtenaw court, but they dismissed it.
Ms. Harrison, what I said to you was the summons in this case indicates that there was a case in Washtenaw County, but that case was dismissed.
Okay.
That case number from Washtenaw County ends in LT, which indicates to the court that there was a summary proceeding, which is what they call landlord-tenant cases. And this court is not sure if that was for non-payment of rent or termination of your tenancy. And then period. The case in this court ends in GC, which means it's a general civil case. And based on what's in the file suggests to this court that it's collections from your previous landlord. So even if the case in Washtenaw County was dismissed, it is a separate and distinct case from this case. An objection, period. An objection to garnishment can only be about something being wrong with the garnishment. Either the funds are exempt, there's bankruptcy proceedings which will stop them from garnishing you. There's an installment payment order. You've paid the judgment in full. What else? The maximum amount permitted by law is already being withheld from some other entity. And then there's the other. And on that other line, you wrote in the case about the dismissed case in Washtenaw. Which is not something wrong with this garnishment. It's you saying that this case was already filed before, but I've explained to you now twice that it was a different type of case.
Okay, well, can I have a 60-day discovery? Because this is this situation is just a lot.
There's no discovery. Well, Mr. Asphalt. Any comments, sir?
Your Honor, I would request that the court deny her request for discovery. There's no open case. The case is concluded. She's not entitled to discovery at this time.
Well, I would like a 60-day discovery because you tried to, because I wasn't even notified about this case until last minute when the Treasury contacted me. And so it's like, this is like last minute. So I would like to have a 60-day discovery to bring more evidence to the court.
Again, Your Honor, I would request that her request be denied. There is no open discovery. There's a default judgment has been entered.
I wasn't even notified of this until last minute from the Treasury, from the tax people. I wasn't even notified of none of this.
Ms. Harrison, Mr. Asphalt is correct. There is no discoverable issue before this court at this time. I've already indicated to you why this court was finding your objections to the garnishment invalid and denying them, and will also deny your request for discovery. I would suggest that you either
So with the Treasury, when you said on the Treasury line that I didn't fill out something to say that something was wrong or that I owed money or something like that, because
I'm sorry. What about this?
No.
I don't understand what you're asking about the Treasury.
yeah, the Treasury, because the only reason I got contact because of my taxes. The taxes didn't go through because they said that Covington, but that's why I was notified. So to say that I'm too late and I wasn't notified, and it's like, what did you even send a notification at for me to be notified that they was even trying to sue me? And I never got nothing from June 2022. I didn't know this was even going on until like last minute. And I thought this was over because it got dismissed in Washington County. And I thought that because I don't live in Wayne County. So I thought that they would come through Washington County court. And that's why
Ms. Harrison,
because
you interrupted me before when I was starting to say that I would suggest that you contact an attorney, or you
Okay.
can go on Michigan Legal Help, and it will give you the information you're looking for. This court is unable to assist you in terms of directing you what you should file next or differently.
Okay.
But because the only thing before the court this morning is your objection to garnishment, which the court has already denied. Mr. Asquith, there was a prepared order in the file. The court has signed that directing the Treasury Department, which somebody needs to fill in that information. The Treasury
do I
Department to
file?
release any withheld funds to you. I'm sorry, Ms.
So
Harrison.
do I file in this court, in Wayne County court?
If you file something in this case, yes, ma'am.
Okay, and even if this case started in Washington court, I can't file in the Washington court? Even if
Ma'am, this
Covington-
case did not start in Washington. The Washington case was dismissed. The case that's
Wait.
in this court started in this court back on February 22nd, 2022.
So this started in 2022 in Wayne County. And so what did they serve the papers at what location? Because I never got no notification of that.
Your Honor, if she wants to file a motion to set aside the default judgment, I guess we could address that stuff at that time. I just don't think it's really relevant. Does the court need me to submit an order or no?
No, Mr. Asphalt, I have already indicated to you there's an order inside the file which has been signed.
Got it. Thank you, Judge.
Ms. Harrison, what Mr. Asphalt said is true and accurate. The address of service on the underlying case is 13658 Beacon Trail in Van
I
Buren
haven't lived
Township.
there over like 5 years. So of course I would not get
Ms.
nothing.
Harrison, Mr. Asphalt has already told you what you need to file. If that's the argument you want to make, what I'm suggesting to you
Okay.
is that what you're arguing is not an objection to the garnishment. You're arguing against the validity of the underlying case, which is different paperwork.
Okay, so how can I argue the objection of garnishing?
Ms. Harrison, see, you're not listening. Mr. Asphalt told you what to file. I've indicated to you that we've already had this hearing now on your objection to garnishment. You're trying to challenge the underlying judgment. Mr. Asquith indicated that's a motion to set aside default judgment, which is a different argument. If you want to file that paperwork in this case, you can file it in this case. Either bring it into the court and file it or mail it into the court with a motion fee. But that's not what's before the court this morning. The court can only take up argument on what's scheduled, and that's the objection to garnishment, which has now been ruled on.
So it was already ruled on before I got to court.
No, ma'am. I asked you this morning. When I said this is your objection to garnishment, present your objection to the court. And you said what you said about the tax garnishment. Mr. Asphalt responded, and I asked you, did you have anything else? And you said no.
Well, I thought the dismissal,
Dismissed. I've explained to you that that case was a different type of case and it was in a different court. And it has, the plaintiff has to indicate that there was a previously filed case on their summons.
okay.
Those
and you
two
can
different
file-
types of cases.
Okay, because I didn't know you can file it in a whole different county if it had nothing to do with that county, even to garnish people's money.
Ms. Harrison, Mr. Asphalt has helped you. I've reiterated what he said to you. I have given you all the language that you need to proceed, but for right now, this matter is concluded for this morning. The order has been signed and copies will be mailed to the parties at the addresses that are in the court's file this morning. That concludes this matter. You both have a wonderful day.
Thank you, Judge. Have a good day.
Thank you. This is 092388GC. This is Calvary versus Nathaniel Mitchell. May I have your appearances, please?
Good morning, Your Honor. Mimi Kalish on behalf of Cavalry.
Thank you. Sir, state your name for the record.
Nathaniel Mitchell.
Thank you. Today is the day and time set for hearing on the plaintiff's motion to set aside the installment payment order. Ms. Kalish, please proceed.
Your Honor, in the breakout room, we had an opportunity to discuss this matter. Mr. Mitchell has agreed to pay in accordance with the previously entered motion for installment payments. I should say order for installment payments, which called for him to pay $300 a month. He indicated that he will make his first payment on July 20th, 2023, with payments of $300 to continue on the 20th of each month thereafter until the judgment is paid in full. Right now, the amount of the judgment is about $3,600, and I can submit an order to the court unless the court has its own order.
Mr. Mitchell, is it your understanding and agreement that you will resume the payments of $300 per month beginning July 20th, 2023, and continuing at $300 per month thereafter until this judgment is paid in full?
Yes, it is my understanding and agreement.
Thank you. Ms. Kalish, there is already a proposed order on your motion, on the plaintiff's motion to set aside the order for installment payments. The court will indicate that that motion is denied because, and I will write in there that the parties have agreed to re-enter the payment plan of $300 per month beginning July 20th. Copies will be mailed to the parties at the addresses we have on record. Is there anything else, Ms. Kalish?
Nothing further, Your Honor.
Anything else, Mr. Mitchell?
No, Your Honor.
Thank you. That concludes this matter. You both have a wonderful day. Thank you.
Thank you.
Yeah.
You too. Thank you, Mr. Mitchell.
Thank you, sir.
Thank you.
And that concludes this court's docket for the day. You're welcome, sir. Mary Ann will stand adjourned. You can take us down.